Thank you.
Mr. Hoffmeyer, are you ready for us? Thank you.
Before I begin, Madam Chair, can I just say that as we speak, the instructing attorney is busy compiling a document relating to the stats that Advocate Norman Arens was talking about yesterday. So I thought it's not necessary for us to wait until he has complied the documents, because my cross-examination in relation thereto will be almost at the tail end. So may I proceed?
I'm loath to ask you how long you think you're going to be, in case you think I want to restrict you. But I'm going to ask the question anyway, because I think we need in our minds to gauge how long this day is going to be, considering that yesterday we said we will work until 12 o'clock. No. We just want to get it in our minds. Yeah. So just more or less tell the panel how long you're going to be. How long you think you're going to be.
At least not more than 1 hour, 30 minutes.
Thank you. Thank you.
Good morning, Advocate Hoffmeyer.
No.
Good morning, but I'm not an advocate, as I said before. I'm an attorney.
An attorney?
Yeah.
Oh.
Yeah, please don't demote the witness.
Demote. Just there when you're talking about being an attorney, how long have you been an attorney?
I've only practiced as an attorney for a relatively short period in the early 1990s, before I became a member of Parliament.
My question was simply, how long have you been? How long did you practice as an attorney?
I think essentially for about 2.5 years at the time. Yeah.
2.5 years. And in the NPA, how long have you been with the NPA?
Since, I think it was May 1999.
You heard my colleague yesterday, Norman Arens. In most cases, he was putting to you that most of your evidence is allegations without factual basis, it's conjecture, it's suppositions. Do you remember that?
I do. But I don't agree with his statement.
Mr. Hoffmeyer, it looks like it's a very unwieldy way of answering. Can't you put your mic this side so that you're going to be very tired turning around that way?
Thank you. I think that's a good suggestion.
I'm going to continue along those lines, but on different facts. In other words, it will be our submission also that, as Mr. Arens has put it to you, we will make similar submissions, but on different facts. So I just want to kick off by dealing with one issue relating to your allegations that the Advocate Mrwebi is facing charges in terms of Section 32 of the National Prosecuting Act. Remember that?
Sorry, I can't remember the details of the section, but
But it's in your affidavit that,
yeah,
that he's facing charges in terms of the provisions of Section 32.
Yeah.
Do you know the facts, the material facts relating to these allegations?
I don't have them before me at the moment, so... Sorry, I don't remember them at the moment, Chair.
They are also not in your affidavit, not so?
If I remember correctly, yeah.
Yes. Did you verify? Did you verify before you came to this? Before you came to this particular hearing, whether these allegations are still pending?
Sorry, you remember the choir master. If you could move it towards you.
Thank you. Before you came to this particular hearing, did you verify whether these charges are still pending?
No, I did not.
Why didn't you do so?
Sorry?
Why didn't you do so?
Frankly, I just ran out of time. I had a huge amount of preparation to do.
And for the record, you are the one who laid the charges against Mr. Advocate Mrwebi. Am I correct?
I don't think I laid the charges. I discussed the matter with Mr. Ngasana. And sorry, I apologize. Let me try and move it closer.
You might want to sit straight, because I know you want to look at him when you respond, but if you sit straight and face, now you have the mic on the side, but sit straight and maybe face the mic, or put the mic in front of you.
Madam Chair, in the absence of some of our colleagues, wouldn't it just be easier if Mr. Ramaweli moved down?
That's a good idea. Yeah. Yeah. So that Mr. Hofmeyer can face this way straight. He's also going to get tired if he keeps on turning his spine, yeah, and his neck. Yeah. Thank you.
Thank you, Chair. I think
Sorry to do that to you, but I'm sure it's much better now.
It's far much better now. It's face to face now. Mr. Hofmeyer, I was just dealing with the issue that you are the one who laid the charge against Advocate Mrwebi.
Can you refer me to where it says that in the documentation?
Are you denying that?
Can you just refer me to where it says that?
No, I don't have to refer you. I'm just asking, are you denying that you are the one who laid the charges? You can deny it. Or you can admit it.
My memory is that the issue, I mean, I was not the one who made the statement in the docket. When Mr. Ngasana was dealing with this matter, he asked me, I sort of went to discuss it with some prosecutors, because he wanted a team to look at the case and to decide whether there is a case or charges. So I didn't lay a charge in that sense.
Okay. I'm not going to take it further, but the issue that I want to further clarify with you in regard to this particular matter is, you made the allegations in your affidavit. You haven't clarified whether these charges are still pending, and what you want the inquiry to do about these allegations under the circumstances?
Can you just tell me which allegations you're referring to?
Sorry, what is happening
Which
there?
allegations you're referring to particularly?
Mr. Hofmeyer, if your legal representative could please refrain from discussing with you.
Madam Chair, I apologize. I'm sorry I've missed your surname, sir, but he was asking a question relating to statements made in an affidavit. My question to Mr. Hofmeyer was, which affidavit and where? I'm merely trying to keep pace with what he's asking, that's all.
If you could, in a sense, refrain from doing that, because Mr. Ramawele did say, I'm not referring you to an affidavit, I'm saying you can deny it. So to ask the witness which affidavit is really not appropriate. Given the indication by Mr. Ramawele.
Yes. Thank you, Advocate Moroka. The question is very simple and straightforward. Is when I'm referring to allegations, I'm referring to allegations related to the contravention of the provisions of Section 32 of the National Prosecuting Authority Act. That's what I'm talking about. I'm saying you came to this particular hearing without verifying whether this case is still pending. What do you want this inquiry to do about this particular allegation in particular, under the circumstances?
I suppose what I'm saying is that the allegation should be taken into account.
Even without you having verified what actually is the position in regard to these allegations?
Chair, I have tried to verify, but I have not got the information yet, but if the inquiry will indulge me, I will get the current status of the
Sorry, Madam Chair, for my sake as well, I'm equally lost in the sense that the proposition put is you have made certain allegations in your affidavit and you've come here without verifying it. And the witness asked, what allegations in my affidavit are you referring to? And I think the witness is entitled to know specifically which allegations he's referring to.
I was referring to the second part of that question, not to that question, and you're quite right. It's the second part where he says, I can't answer if I didn't say that in an affidavit. But you're quite right. If you're going to refer a witness to an affidavit that he made, that is amongst us, we know which one it is. I think the witness is entitled to be told which affidavit because he's made more than one.
Well,
it is now that question that we need to address. Okay.
I'm referring to the allegations on page 167 of the affidavit, which is the affidavit which is filed in respect of the matter of the Democratic Alliance and the Acting National Director of Public Prosecutions. It will be on page 167 and it's paragraph 472. I didn't want to...
Date? What's the date?
This affidavit is dated... is the 2015 affidavit.
Okay, check 67, because I have 67.
You see paragraph 472?
Yes, I do.
Yes. So, I don't want to read the paragraph. All I was asking you is, what do you want this inquiry to do with these allegations when in fact you haven't verified what the current status of this particular matter is?
As I indicated, I'm happy to verify that if I'm given the opportunity to do so.
Mr. Ramawele, sorry, what page did you, we have it as page 214.
It's 214, yeah, on mine as well.
Paragraph 472. Ms. Power, what have you got at 214?
Yeah, I think my papers are not properly paginated, but it's paragraph 472.
Yes. Yeah. Page 214.
Okay, but you have located it.
Yeah, it's 472.
Yes.
Yeah.
I think the paragraph is important.
Yes. So you say you want to verify?
I would assume that if you say to me that the charges are no longer in court, I would not dispute that, because I would assume that Mr. Abrams, while he was NDPP, that the case may not have been pursued by him.
Now, this is what I'm putting to you, and I just want also to remind to you that this is the reason why my colleague yesterday was saying to you that you make wild allegations which are not substantiated. Now, can you understand why that statement was being made? I'm also saying in this particular issue, it's the same issue.
I don't. The affidavit in which I made the statement was correct at the time when I made the statement. So I've not put I've not said to this inquiry that Mr. Mrwebi is currently facing charges.
Okay. Let me close off by just putting to you about the current status of these particular allegations and move to another topic. The charges against Advocate Mrwebi in respect of the contravention of Section 32 of the NPA Act were struck off the roll in 2015. In 2015, because the national director had decided not to proceed and wanted to refer the matter to outside counsel for consideration of whether there was a prima facie case. That's what happened.
Yeah, I was not aware of that.
Yes. Now, let's deal with the issue of the interference in the Mrwebi matter. You have been an attorney for about 2 years or so, so you have not prosecuted before, obviously.
No, I did not. I've defended some clients in criminal cases, but I haven't prosecuted before.
Yes, but I would assume that if you have defended some clients in a criminal matter, you will know that all that witnesses have to do is to present the evidence and not to draw inferences. Am I correct thus far?
I agree.
Now, in regard to the interference in the Mrwebi matter, on what factual basis do you base your allegation that Advocate Mrwebi interfered in the Mrwebi matter, other than inferences?
My understanding is that there is more than an inference, and if I recall correctly, that he supplied minutes of a DSO meeting to Mr. Celebi to aid him in his application for permanent stay.
So, the basis upon which you allege that Advocate Mrwebi assisted Celebi is that he provided the minutes of the DSO meeting to Mr. Celebi to assist him in his application for a stay.
That's correct. I wouldn't say, I'm not sure if Mr. Mrwebi knew that this permanent stay was being brought, but he provided the minutes that were used in the permanent stay application.
The same paragraph, I just want to clarify certain issues on this particular issue. Let's go to paragraph 454 of the same affidavit. I don't want to refer to the pages. Paragraph 454. Are you there?
I am.
I just want to read you the third sentence. The third sentence says, or let me rather read the whole sentence. It says, he filed 2 affidavits in support of his application. Who are we talking about here?
Celebi.
Okay. The first was Agliotti's affidavit. The second was an affidavit by Lawrence Mrwebi, a special director in the NPA. As pointed out above, Mrwebi supported Celebi's claims that his arrest was a political strategy on the part of the DSO and that he was deliberately targeted. So the minutes that we are talking about, are you referring to this affidavit?
Yeah.
You are referring to the affidavit? Okay. I just want to refer you to Madam Chair, if I can just...
It's okay, we'll be patient.
I just want to refer you to paragraph 464. Where you discuss the meeting of the 25th of June 2007. If I can begin, where you say, Mrwebi is the former head of the NPA Specialized Commercial Crimes Unit. Mrwebi deposed to an affidavit alleging that at a meeting held on 25th June 2007, the DSO had considered strategies to reverse a decision to bring the DSO under the control of the SAPS. Silebi used Mrwebi's affidavit in support of his application for permanent stay of prosecution. He claimed that Mrwebi's affidavit proved that the DSO investigation and prosecution of him was a strategy to ensure the survival of the DSO. Do you see that?
I do.
If you read the two paragraphs together that you have written, you will see that the converse is the truth. What you are saying is Silebi actually used Mrwebi's affidavit. Mrwebi had made an affidavit. And then Silebi had used that affidavit in support of his application for a stay. Am I correct?
That's correct.
Would you also agree, or do you know, that when Advocate Mrwebi made the affidavit, he was making an affidavit not to assist Silebi. He was making an affidavit pursuant to an investigation that had ensued in regard to the Browse Mole report. And do you agree thus far? Or do you know?
You may be correct, but I mean, I can't.
Yes,
it's a long time ago,
yes,
but
yes,
I think
yes,
you may be
yes,
correct about
yes.
that.
And the meeting of the 25th of June 2007 of the DSO was actually a meeting where the DSO, or let's put it this way, the DSO will be a unit that was within the NPA. Am I correct?
That's correct.
And in 2007, the ANC had taken a resolution to the effect that it has to be disbanded. Am I correct thus far?
That is correct.
So the DSO, the meeting of the 25th of June 2007 was a meeting of the DSO where it was being strategized. I'm just made to understand that where you say June, it should be July. So it should be 25 July 2007. That the meeting of 25th July 2007 was a meeting where the DSO was strategizing or deliberating on how the DSO can remain within the NPA. Am I correct thus far?
Maybe I should just tell you what my remembrance of the context is. I think the ANC decision you're talking about was taken at the ANC policy conference.
Yes.
So that's not a binding decision.
Yes.
I think it was reiterated later
Yes.
at the
Yes.
ANC conference
Yes.
itself.
Yes.
But yeah, clearly I think the DSO perceived that there may be that there is a likelihood.
It might be implemented.
Yeah.
Yes. Yeah, but I'm not really focusing on that.
I just wanted to get the context correct.
Yeah, sure. But all I'm saying is, because I'm trying to make the panel understand this meeting of the 25th of July 2007 was a meeting where the DSO, where Advocate Mrwebi was also in that meeting. They were deliberating on how best it can be done to have the DSO remain within the NPA. Do you know about that, or don't you know?
I mean, I've heard about it. I obviously wasn't in the meeting, but I read about it subsequently and heard about it.
Yes. Yeah. So during the Browse Mole investigation, can you just enlighten, just in brief, the inquiry as to, in short, what was the Browse Mole investigation about? Just brief, because it's not so much relevant.
Essentially, it was a sort of semi-intelligence background document on a range of allegations that I think Ivor Powell was one of the analysts at the DSO, that him and other had picked up, and they put it together in a document. So it has a range of,
and there were accusations.
Let me call it intelligence material rather than evidence.
Yeah.
But,
and there were allegations against former President Zuma, who was not yet a president, that he was
included. Yeah.
Yeah, that he was trying to overthrow the government with the assistance of foreign agents. Am I correct?
I'm not sure to put it that strongly, but that may have implied it.
Yes, yes. So during that investigation, it then transpired that the investigators then got to understand that there was a meeting of the 25th of July, 2007, and Mr. Mrwebi was there. So he was then requested to make an affidavit in regard to...
Just remind me who was doing this investigation.
Was the meeting in June or in July?
July.
Yes. Thank you.
National Security Council. National Security Task Team. National Security Council Task Team. So, I just want to wrap up the issue of the interference in Mrwebi, but the background is very important. So, whilst these investigations were going on, it became apparent that there was a meeting of the 25th of July 2007 where Mr. Advocate Mrwebi had attended. And that is why he was then requested to make an affidavit in regard to that particular meeting.
Sorry, Mr. Ramawel, I'm really confused. The chair asked you what's the date of the meeting, and you say July. Is this the meeting referred to in 464?
Yes, 464.
But it says 25th June.
Well, I clarified it with the witness.
Oh, sorry, I didn't hear that it was
I clarified with the witness.
Okay, sorry.
Yes. I was asking you as to the fact that after the investigators had realized that in fact there was a meeting of the DSO on the 25th of July 2007, and where Mr. Mrwebi was involved, they then requested him to make an affidavit.
Is that a lawful investigation? My understanding is it was not conducted by any law enforcement agency.
Well, it
was intelligence people doing an investigation, and I think the issue is whether NPA people who are bound by the provisions of the law not to disclose information about the NPA have some legal basis to cooperate.
Well, I'm just putting it to you. You cannot put statements to me. I'm just putting it to you. That's all I'm doing. And after he was then requested to make a statement, then subsequently, just bear that in mind, when Mrwebi made his application for a stay, he used that affidavit in support of his application. Do you agree?
That's correct, yeah.
Now, if we look at now what happened, can you now see that it is not correct to suggest that when Mr. Mrwebi made the affidavit, he was making it to assist Silebi.
I think I'm not sure what was in his mind, but I think the effect was to assist Mr. Silebi, and he was not authorized to make that affidavit and to disclose that information to whoever he disclosed it.
So finally on this issue, are you saying if I make an affidavit in the course of a particular investigation and subsequently somebody takes my affidavit without my consent and puts it in a court application to assist him, you will still maintain that I'm assisting that person?
My issue is, I don't know what was in Mr. Mrwebi's mind at the time and whether he knew or didn't know that it may be used in relation to the Silebi case. But the issue is that it was not lawful for him to depose to that affidavit. If it had been a police investigation on a proper basis somewhere, then there may have been a case why he should make an affidavit like that. But this is the spooks coming to say, please tell us what happened there, or, I'm not sure who initiated the conversation. But it's simply, in terms of the NPA Act, it was not lawful what he disclosed to them, and it was not lawful for them to make a request for him to do so.
Well, yesterday my colleague was saying you are making a political speech, but today all I can put it to you is that you are making a whole lot of statements, but you are actually not addressing the actual question that I put to you. So we are still back to where we were with Norman Arendse. Because the question that I put to you in closing, which you chose not to answer, and I will repeat the question. And if you still don't want to answer the question, then I will move to another topic. All that I said was, if somebody makes an affidavit in the course of a particular investigation and related to a particular issue, and subsequently another person takes that affidavit without the consent of the maker of the affidavit, would you still say that the maker of the affidavit was assisting the applicant?
I think in the circumstances where he makes an affidavit or provides information that is not legally entitled to do so, he does not seek permission from the national director, as he could have done, to say I've been approached about this. He did not seek permission from the head of the DSO about doing this. I concede that I may have drawn certain conclusions about the intentions behind it, but in practice that affidavit got used to help Mr. Silebi in his efforts to escape justice.
Well, let's put it this way. But did Mr. Silebi escape justice? Did I hear you properly?
He got quite close in the permanent stay of in his permanent stay application. It was a bit of a miracle that we won that case.
Advocate, Mr. Hofmeyer, you just said to the inquiry he escaped justice.
No, I said it was an effort to help him to escape justice. Maybe I left out a qualification there. But the affidavit was used by Mr. Silebi to escape justice. That was the impact of the affidavit.
Yeah. And you also just said that you may have misunderstood his, you may have, how did you put it? You may have drawn conclusions from the usage of the affidavit, which you shouldn't. Did I understand you properly?
I think I drew an inference.
Yes,
yeah,
yes,
which
yes.
I concede it is an inference.
Yes, which is not justifiable. Do you agree?
Sorry, which is not?
Which is not justifiable under the circumstances. Which is
justifiable or
yes,
justiciable?
Yes, justifiable under the circumstances. Yeah. Or justifiable, if you want to put it that way. Yeah.
I think it was not unreasonable in the circumstances, but I concede that it is an inference.
Okay. Lastly, on this topic also, you know that there was some allegations of misconduct on the part of Advocate Mrwebi emanating from the Browse Mall report. And that you were suspended also?
Yeah.
Okay. Madam Chair, I just want to refer the witness to a labor court order. We do not have the judgment, and we gave the documents yesterday, and I just want to refer the witness to this particular order.
Do you have
I've got the court order with me.
copy of the order that you can give to him? Do you have a copy? Thank you.
Have you read? Is a two-page document. Do you see it?
I do.
Do you see that? Do you see that there was a final interdict granted in favor of Advocate Mrwebi in respect of the holding of a disciplinary inquiry?
I do.
And our submission would be that the allegations emanating from the Browse Mall report or investigations, he was able to successfully interdict the NPA from proceeding with a disciplinary inquiry because those allegations were baseless. Any comment?
I would have to refresh my memory about the exact things that happened in the course of the Labour Court proceedings.
Okay.
I know that eventually, I think it was both Ms. Jiba and him that came back to the NPA at that time. The NPA had not been consulted. It appeared that it had been the Minister of Justice or the DG of Justice who'd entered into some settlement agreement that they should return to the NPA, but the NPA management was not involved in that decision at all.
But are you stating that as a fact or what?
As I said, I would like to just refresh my memory with the documents on exactly the sequence of events, but my memory is that, you know, both Mr. Mrwebi was simply informed at the time that they would be coming back. We were not aware of the settlement that had taken place.
Mr. Ramole, sorry, I'm a bit uncomfortable with the circumstance where an order is just simply given to a witness. We don't really know what is in the order as the panel, and we would also like the benefit of a at least having some reasoning behind the court making that order?
Well, Madam Chair, this particular document was given yesterday, and as I said, we do not have the judgment, and we do not have the judgment at the moment, and that judgment can be put in the Dropbox as soon as it is found. So I don't know whether we should, in the spirit of trying to facilitate the proceedings, whether in fact, I don't know. I'm in your hands.
The judgment itself would give a context to the order. You now want to address the order. You've given the order.
Yes.
Have you? What the panelist is asking is for us to get the order.
Well,
because the judgment gives a context to the order, it can be placed in the Dropbox.
yes,
But
that's
right now we want to address the order.
Yes.
So it would be helpful
Yes.
if we have the order, the same one that you gave to him.
Well, the copies. We made enough copies. I don't know why you don't have copies.
I only got one copy.
I'm sorry, Madam Chair, because we had lots of copies yesterday, so I'm just surprised why all of a sudden.
Thank you.
Yes, thank you.
You may proceed.
Can I also say that Advocate Mrwebi has the actual judgment in his laptop, so arrangements will be made to have it in the Dropbox.
In the Dropbox.
Yes.
Thank you.
Yes.
I know. Let's see the rest of it.
Mr. Hofmeyer, I now want to deal with another issue, the NEL issue. The other allegation that you have against Advocate Mrwebi is that he assisted or he interfered in the arrest or he interfered in the, or what is the specific allegation in respect of the NEL issue, if I can put it that way?
Are you now dealing with the order?
No, I'm dealing with Mr. NEL.
No, we want to know what is the order issues.
Oh, sorry,
Yeah.
Madam Chair.
Madam Chair, sorry to interrupt you, Mr. Ramaweli, but the proposition was put that the final interdict was granted by the Labour Court, and I just got the order back. It doesn't say it's a final interdict.
It says pending. Yeah. Just I think go over it again. Let us know what the issues are, because now this order is not final.
Let me just read the order. Oh, yeah.
Why? Yeah.
Yes, I withdraw my statement. Yes, it's an interim order.
Yeah.
Yes, it's an interim order. But it was an interim order related to Mr. Hofmeyer. As I said, it related to the misconduct allegations which were which were leveled against Advocate Mrwebi in regard to the Brown Mole report.
So you withdraw the statement?
No, I'm just putting it. I'm just putting it properly to say that
okay.
it is an interim order. Yes, not a final order. Except that it's an interim relief, interim order, but it relates to the allegations that he faced arising from the Browse Mole report. Any comment?
I did ask for some indulgence. Just to refresh my memory. So I can't be sure, but I think Mr. Mrwebi was suspended at the time. I don't think the interim order had the effect of lifting his suspension, but maybe you can enlighten me about that.
Well, all that I want to put to you finally on this issue is that the allegations emanating from the Browse Mole report were never pursued at all by the NPA.
It was, I mean, the NPA management, if my recollection is correct, tried to pursue it, but when Mr. Similani was appointed as NDPP, I accept that the NPA apparently decided not to pursue any of these allegations, partly because they had been, Mr. Similani, as is well documented, was part of the efforts of protecting Mr. Mrwebi.
Well, Mr. Similani is not here to answer for himself, so let's stick to the question that I asked you.
Sorry, which is what?
Because you don't respond to the question, that's why you forget.
Just repeat the question for me, please.
My question was simple. These allegations were never pursued by the NPA.
They were pursued by the NPA until Mr. Similani was appointed, if my memory is correct, but I would like to refresh it with the documents.
Let's deal now with the interference relating to the arrest of Mr. Nel. What is your specific allegation or complaint in regard to the alleged interference by Advocate Mrwebi in regard to the arrest of Mr. Nel?
My specific complaint is the information that he gave to the police about the management meeting.
What management meeting?
The DSO meeting where the disbandment of the Scorpions was discussed.
What has that to do with the arrest of Mr. Nel?
I think it was used in the application to try and taint Mr. Nel in various ways. I mean, as one of a number of ways to justify his arrest.
Mr. Hofmeyer, I assume that as a senior member of the NPA, you would want to uphold the rule of law.
I do.
Now, you know that Mr. Nel was arrested pursuant to a warrant of arrest authorized by a magistrate. Am I correct?
That's correct.
Now, and that warrant of arrest was never reviewed or set aside. Not so?
I can't say I remember, but yeah, I just don't know the answer. I can't contest what you're saying. I'm just saying I can't. Yes. I don't know.
Yes. If somebody gets arrested pursuant to a warrant of arrest authorized by a judicial officer, we have to assume that there's some kind of evidence against that person. Not so? To justify that arrest. Because it's based on a authorization by a judicial officer.
I think there is a longer story about a number of prosecutors who were approached to authorize that warrant and who refused. And I think that's part of the papers in this matter, where a significant number of prosecutors said there is no grounds for such a warrant.
I'm not asking about prosecutors. I'm asking about judicial officers. I'm asking about a magistrate. That's what I'm talking about. Because here we are talking about a magistrate. It's a different kettle of a fish. We're talking about a magistrate. If a magistrate authorizes a warrant of arrest, what does that mean? You have been in the asset forfeiture unit for so long. You know if it's a magistrate who has authorized a warrant of arrest, you know that either you've got to review it and set it aside, but you can't now say that the arrest was unjustified.
When it was held subsequently that it was.
I'm not talking about the subsequent proceedings. I'm not talking about the subsequent proceedings. I'm talking about the, because if we were to second guess the authorizations of judicial officers, then there will be chaos. You understand? Do you understand? It's like a judgment.
I do agree, but
Yes.
judicial officers
Yes.
also do make mistakes, or
Yes.
sometimes they may not have all the information placed before them, or whatever the reasons were, I'm not sure.
But if there is a court order, there is a court order. Or if there is a warrant of arrest authorized by a magistrate, there is a warrant of arrest. It's not questionable until it is set aside.
I may not be remembering correctly, but I think in terms of the policy, prosecution policy guidelines of the NPA, any action taken against police or law enforcement personnel needs to be discussed with the NPA prior to that action being taken. I can get you a more exact reference, but I think that is stated in our prosecution policy directives.
Mr. Nell was released in an was it in an agent application?
To
Yes.
the High Court. Yeah.
Agent application in the High Court.
Sorry, I may not remember correctly.
Yes,
It may
yes.
have been in the magistrate court.
Yeah. And what was your role in the release of Mr. Nell?
I basically received the information that he had been arrested. I contacted a number of people to try and find out where he was, because the police refused to tell his family where they were taking him. So we kind of organized through the night for various people to track him down, and I think we eventually tracked him down at the Moot police station, despite the fact that the police wouldn't give us the information where he was being held. We then arranged two legal teams, one to deal with getting him released on bail the next day, which he was. And around that time we also got served with the permanent stay application for Mr. Mrwebi.
So if I understand you properly, you are a senior member of the NPA, but you were also playing the role of some kind of a defense lawyer for Mr. Nell.
I was not playing a role of a defense lawyer. I wasn't in court. I tried to organize legal representation late at night when his family could not find legal representation.
But you assisted the attorney of Mr. Nell.
I tried to. I think the attorney was found by the family. I mainly played a role in arranging for counsel for the bail hearing and then for the urgent application.
My question was, you assisted the attorney for Mr. Nell?
I don't think so.
You are sure?
It's a long time ago, but my memory is that what I was working on was the finding the legal representation for him and trying to track down where he was being held and preparing for the urgent application that was served on us.
Let's go to page 4. Let's go to paragraph 445 of the same affidavit. It says, Nell's attorney, Lisk, and I went to see him and started to prepare an urgent application to have him released.
Yeah, so that's what I was saying, that my role was around the urgent application.
Do you understand? Can you now see why I say, although you were a senior member of the National Prosecuting Authority, you were also some kind of a defense lawyer, because you and Nell's attorney went to see him and started to prepare an urgent application to have him released. So you were together.
I was not playing a role of a defense attorney. We were in a position where there was a concerted attempt to make the Mrwebi case go away, as was evidenced by the urgent application that was served on us. We needed Mr. Nell to be out of jail to help us prepare papers for that urgent application. So his attorney was his attorney. He dealt with the bail application. I didn't deal with the bail application. I wasn't even there at the bail application. But what we did try and do was deal with the fact that the police refused to tell us where Mr. Nell was being kept. And we had basically to send out search parties and try and get information from various policemen that we knew to try and track him down.
You had my colleague yesterday saying that if I remember his words, you were saying something to the effect that you were part of those who were making the NPA dysfunctional. You had that?
I heard it. I don't agree, but
yes, your participation after the arrest of Mr. Nell in our submission, which we'll put to the panel, demonstrates that particular submission which was made by Advocate Arendse yesterday.
I think it's difficult not to read sinister motives into his arrest when it was well known where he was, that no authorization had been obtained from the NPA as required to arrest him. And when almost at the same time an urgent application is served on us for a permanent stay of application for Mr. Mrwebi. I don't think one needs rocket science to say that there was a concerted attempt to get Mr. Mrwebi off, and that the arrest of Mr. Nell was very much part of that.
Madam Chair, I just want to just briefly deal with the issue of the stats, just to place them on record.
Are we done with the Nell?
Yes, yes, I'm done with the knowledge. Thank you. Madam Chair, I'm not going to ask many questions on this issue. I just wanted to clarify something which Norman Arens was dealing with yesterday, and just one question on this particular issue. Mr. Hofmeyer, you remember that yesterday that your evidence was that there was never any custodial sentences in regard to corruption cases. Remember that?
I made it in the context of the period a bit later than some of these stats. I did not say in the early days of the anti-corruption task team there was no custodial sentences. I reflected on the period after that. And
I think if you start from page 2, page 2 should be page 1. I just want to say that.
Sorry, I'm not sure I understand you.
Page 2 is page 1.
The one marked.
Page 2 is page 1.
But it starts with the amount of 6.1 million.
Yes. Yes.
But Chairperson, I'm not disputing the list. I recall, sorry.
You may proceed, Mr.
I'm not disputing the list. I'm relying on a statement that the then head of the SCCU, Ms. Marlene Govender, made in Parliament, where she was questioned about 86 cases that were done under the ACTT, and where she was subsequently asked what were the sentences in each case.
Yes.
And it was in that report that it emerged that nobody received custodial sentences. So that's a document I refer to. I completely accept that in some of the earlier years the job was done properly. It just wasn't done properly later.
When you say later, which year are you talking about? Because we have the stats. We have the stats with us here. The only difficulty was obviously we had to find the stats whilst Norman Arens was cross-examining you. So, what year are you talking about when you say the later years?
Mr. Ramawel, can we just, before you proceed with interrogating this document, can we just identify it? What is it? Where does it come from? What are these stats about? No, is it also part of an annual report? Which annual report? And yeah. And let's just get the document right first, né? So that we all have a common understanding of what it is and what we intend to do with it.
Can I just ask my client to describe what the
Chairperson, is actually this internal statistical information of the SCCU in relation to serious corruption, including fraud, which is dealt with by the anti-corruption task team of the NPA. Is the information that we collect on an annual basis to show the status of convictions and the sentences that have been imposed in respect of what types of crimes.
So it is an extract of a bigger or a broader report or something? An official document, a report?
Yes, it is actually a compilation of information based on source documents, your charge sheets from court, the information that we receive from the prosecutors is actually compiled on that basis.
I want to know, what is it part of?
It would be part of our reports that we present to Parliament. It will be part of the reports that we present to various committees in the JCPS cluster system.
All right, thank you. And this was for the period April, 1st April 2010 to the 31st of March 2013.
If I may just explain, Chairperson, we just extracted this. Otherwise, we've got periods up to 2017, 2018, because we could not print the whole document. We've got the statistics to show for the whole period from 2012 up to 2018, actually. This is just an example of what we could print out.
Mr. Ramawel, because I have difficulty in your client interposing.
But
I understand and appreciate it, yeah. I would rather that we do this quite differently, because I don't get a sense, one, about authenticity, two, about what is reflected in the documents themselves. For instance, if you have amount involved, date of sentence, description of case, you don't have, we remember, if you recall yesterday, Mr. Hofmeyer said, I'd want to unpack the statistic, get the names of the accused. I would want to do that too, so that I get an understanding of documents that we have. So maybe if we go back and look for a better statistic. For instance, if you've got amount involved, 6.1 million, date of sentence, you have nothing, description, unlawfully transferred money, you don't have conviction or acquittal, you don't have, I mean, there's too much that's missing. The statistic makes absolutely no sense, and it's very difficult if you're going to put it to a witness. I'd rather if we compiled a proper statistical record that we can then understand, then accept, and then ask some witness some question. This one for me is really, but you see, page 2 is better. But even then, there's a bit of a problem with page 2, because I don't know whether page 2 relates to page 1, whether it's the same period or whether it's not the same period. I just think there's a bit of an issue.
Well, okay, we know that you said what you gave us. From what you gave us, the page 2 is actually page 1. Okay? And then what was page 1 is page 2. And then page 3 is fine, page 4 is fine. Now when you look at page 1, we have gaps with regard to the date of sentence, as Ms. Moroka has indicated, okay? But you go to page 2, the corrected page 2, I think it shows what the headings there say they must show. So to page 3 and page 4. What we need, yeah. Some of the pages have names, others don't have names. On page 3 we have names. On page 2 we have names. We have number of persons. You think page 4 is page 2?
Yeah, I think page 4, for example, is page
Must be
2.
page 2.
If you look at the way that it's narrated. So,
description of case.
I'm
Yeah,
sorry.
I think there's some
Yes.
confusion. If we can just arrange this document properly, let it show what you intended to show us, and also identify it as an extract from a report or statistical report, so that we don't just have a document.
Can we deal with it in
Yes.
our evidence?
Yes. That would be.
Because
That
in
would be
any way,
great.
he's relying on hearsay evidence.
Yes.
His evidence that there has never been a custodial sentence is based on hearsay.
If you want to use it appropriately and identify it appropriately, and so that we can also make use of it in the report. Ne. Mr. Rep? Okay, just let Mr. Rep say something.
Ma'am, I think the problem is that it's a spreadsheet, so it actually goes across several pages from the side. But I think to get it right, perhaps after the adjournment for the sound people, which normally happens at about 11:15, we can try and get the document in the correct format. And
There's
deal
no
with it
break
after
today. I have to go.
Remember, we're going until
I don't,
12.
well,
This is
if
what
there
we
is an
call
adjournment, we'll
parcela.
try and fix it up somewhere and deal with it later then.
Yeah, let's fix it up, okay? Because we want to use it authentically. Okay, thank you. And that probably goes with yesterday's. Yesterday's was also, it's, yeah. Okay,
Do it on landscape.
okay, you continue evidence.
Just that it's this way, not that way.
Thank you, you may proceed.
Can I proceed? I just now want to move to my final topic.
Out of time, ne? So
Final
you think
topic.
you're clever. Okay, you can proceed.
Mr. Hofmeyer, in your evidence in regard to the provisions of the drafting of the provisions of Section 24.3, you indicated that it was one of the last issues that was dealt with before the adoption of the Constitution. Did I hear you properly?
You're talking about 24.3 in the Constitution?
24.3 in the NPA Act? Or,
The
Oh,
Constitution was drafted before
oh
the
yeah,
NPA.
yeah, no, I'm sorry. So which provision were you talking about when you say it was one of the last provisions?
I think the big issue in the committee in the Constitutional Assembly that I chaired was, at that time there existed DPPs in the various jurisdictions that had the exclusive power to prosecute in their jurisdiction. I think what the ANC to which I belonged at the time wanted was to have a single national prosecuting authority with a head. And that became, as I indicated, became one of the most heated topics of discussion and was one of the last issues to be resolved. So the compromise, as I indicate, was essentially that the DPPs would remain fully in charge of prosecutions in each jurisdiction, and that's changed to the provinces later, but I'm just using the jurisdiction word for the moment. And that the NDPP would have review powers, essentially, and policy-making powers. So you could prescribe a prosecution's policy, you could take action if the policy wasn't followed, but also individuals who felt unhappy about the decision by the DPP could ask the NDPP to make a formal review of their case, essentially.
Can I just stop you there because my interest is more on perhaps I misunderstood you. My interest is more on the provisions of Section 24.3, which is applicable in this particular, which is at issue in this inquiry. Your evidence, and you can correct me, was that it has always been clear that in consultation with means with the concurrence of.
Indeed.
And that the decision that Advocate Mrwebi took on the 5th of December was therefore unlawful because it was not with the concurrence of Advocate Mzinyati.
That's correct.
Okay. Before I get into to the issue that I want to address, I just want to draw a distinction between the applicability of the provisions of Section 24.3 of the NPA Act, the phrase in consultation with, and the phrase in consultation with outside the province of the National Prosecuting Authority. In other words, my submission is in the NPA, in the National Prosecuting Authority, particularly when you deal with the Special Director and the DPP, the provisions of 24.3 are not implementable.
I disagree.
Okay,
And,
we'll come to
but
that.
it is the law.
We will come to that. We'll come to that. Let me just start by giving you an example, not within the NPA. I'm not saying this example is applicable here. I'm just giving an example to, just so that when we come to the NPA, then you can better understand what I'm talking about. There is a case which recently was in the High Court in Pretoria, the so-called, I think it's Kolobeni case, where it was held that the Minister of Minerals can only grant a license to a party, or a license can only be issued to a party, and where it involves ancestral land, it can only be done in consultation with the said community. So it's the same phrase. So if somebody applies for a license, it involves ancestral land, it can only be granted with the consent of the community. So there, and I want the panel to please understand what I'm driving at here, is that if there is no agreement between the community and the minister, as the law currently stands, there is no license. There is no license. It's as simple as that. And the applicant for a license will have to go somewhere else and seek another license somewhere else. So there, it's not controversial. It does not create any dispute. Now, let me, do you want to comment? I was just, as a way of introduction, just giving you this example as a way of introduction. I know I don't expect you to have read the judgment.
Yeah, no,
I'm not saying you should even want me to give you the judgment.
No, that's fine.
Okay, fine. Now, in the NPA, now here is the issue now, in the NPA, particularly 24.3. Where it's about discontinuing or instituting proceedings, the special director has to act in consultation with the DPP. We agreed thus far. Mr. Hofmeyer, we agreed.
Agreed.
And we are also agreed that it means there has to be an agreement between the two functionaries.
Odds don't work.
Mr. Hofmeyer.
Just register your agreement.
Sorry, I agree.
Okay. Now, you know that the evidence of which is on record of Mr. Mrwebi is that he consulted with Advocate Mzinyati on the 5th of December 2011, and according to him, the consultation that he undertook with him was sufficient for purposes of 24.3, and of course subsequently we know that he was wrong, but according to him it was sufficient for purposes of 24.3. This is what is on record. What is your comment?
My comment is that the law is very clear.
Okay, sure.
And that it is not an issue for debate
Yes,
in our law at all.
Yes, we are coming to the practicality of the implementation of 24.3. Now, let's take a situation where, like in this instance, the special director wishes to withdraw or discontinue proceedings, and the DPP wishes the matter to proceed. So there is an impasse.
There isn't an impasse because the status quo has to remain if there is no agreement.
But
the special director has to continue with the prosecution.
But he can only do so with the concurrence of the special director.
Sorry?
All I'm saying is
Sorry, you're saying
the special director, Mr. Mrwebi, takes a view that the matter has to be discontinued. The DPP takes a view that the matter has to be continued. But both do not agree. So there is an impasse.
no, what remains is that if a prosecution has been instituted, it remains instituted. If there's no agreement that it should be discontinued. It's not a complicated issue.
Well, I hear what you say, but all I'm putting to you is if he has taken a decision to, or he wants to discontinue the proceedings, there has to be some form of, or let me put it this way. Let me refer you to Justice Yacoub, because Justice Yacoub was dealing with the same issue that I'm dealing with. Madam Chair, can I just refer you to the report of the report by Justice Yacoub? It will be on folder F1 1.2. Are we there?
We don't have it on our...
Come again?
We don't have it on our pad here. If it's big enough
Can
on
you
the
make it-
screen, maybe that will help.
Yeah. We have it on screen.
I just want to go to paragraph 11.
Can we make it a bit bigger still, please?
Make it the biggest that you can. Yeah, good. Can you see that now, Mr. Hofmeyer? Yeah, thank you.
And I just want to read paragraph 12. There is an aspect of relationship between the special directors and the directors of jurisdiction which appears to be uncertain. Special directors may conduct prosecutions of their own in particular high court jurisdictions, provided that the director, who is head of the office at the seat of the high court, agrees. But the NPA Act is silent about whether the special director can take over the conduct or discontinue prosecutions instituted in a particular jurisdiction by the director of a jurisdiction or a prosecutor. We are of the view that the special director can take over or discontinue prosecutions subject to the requirement of section 24(3) of the NPA Act, namely only with the agreement of the director of a particular jurisdiction. Then I just want to read paragraph 21. Quite apart from the indications as to the necessity for a judicial commission of inquiry, it is necessary for the national director to give directions to all special directors that criminal cases cannot be instituted, conducted, or withdrawn without the concurrence of the directors that head up offices at the seats of the High Court or the various jurisdictions of the NPA. In case of any dispute between the special director and the director, the decision of the director prevails. However, if the director is not happy,
if the special director is not happy, you must read it.
in the case of any dispute between the special director and the director, the decision of the director prevails. However, if the special director is not happy with the decision of the director, he or she may make representations to the national director. All directors of public prosecutions are obliged to work under the directions of the national director. This makes it possible for the office of the national director to put in place a procedure for managing disputes between a special director and a director who is the head of office or jurisdiction about whether a prosecution should be instituted or withdrawn. The issue, Mr. Hofmeyr, which is on page 21, the last sentence, where it talks about in case of any dispute between the special...
Paragraph 21 or page 21?
Paragraph 21, where I read, in case of any dispute between the special director and the director, the decision of the director prevails. And however, the special director is, if the special director is not happy with the decision of the director, he or she may make representation to the national director. We are saying this is the difficulty that Advocate Mrwebi found himself when he consulted with Advocate Mzinyati, because he thought that the consultation that he had with him was sufficient, and he thought that his views prevailed as a special director.
On what basis would he think that?
Well, on the basis that there was a dispute between them.
But the Constitution and the Act is very clear that there if there's no agreement, there's no decision.
Lastly, on this particular document, I just want to refer you to to paragraph 24, which says, consideration should be given to the establishment of a mechanism to deal with cases where, in spite of the director's final decision about whether a case should be withdrawn, the special director is still not happy with that decision. In these cases, the national director, who directs both the special director and the director, may direct that in a case of that sort, if either the director or special director so request, I can't read further. But I just want to read the last sentence, which says, we make this proposal because we are of the view that compliance with the prosecution policy by all personnel within the NPA is an overriding constitutional requirement. In short, what I'm putting to you is, where there was, I know that you disagree, but I'm putting it to you, where there is a dispute between a special director and a director to discontinue or continue a prosecution, there was no deadlock breaking mechanism.
I'm not averse to finding a mechanism to deal with it.
Finally, I just want to put it to you that
Sorry, can I just complete my sentence?
Yes.
I think the proposal that Judge Yacoub makes may be feasible, but it will need a change in the law to cater for it.
Well,
Unless, I'm not sure that the current review mechanisms in the NPA Act allows one DPP to take a decision of another DPP on review to the NDPP. But I haven't applied my mind, but I at the time did not think that this is a feasible proposal. And, you know, frankly, this proposal is not so difficult to implement, because a DPP, the deputy DPPs in each province can be given the same power as a DPP. The DPP can put a deputy into the SCCU, and that person can be the person who concurs or doesn't concur with the decisions. I mean, a solution is not difficult in the framework of the law. But the problem here is the Constitution provides that the DPPs have absolute authority over cases in their division. And you cannot come up with a mechanism that undermines that authority of the DPP.
Well, Mr. Hofmeyer, it appears to me that you are not even familiar with your own documents within the NPA, because I just want to finally refer you to the prosecution policy directives of 1 June 2015. I don't know where in the Dropbox this document is.
And what's the date of that?
It's 1 June 2015.
1 June 2015, oh, okay.
1 June 2015. I just want to read these two paragraphs, then you can see how the dispute that I earlier engaged with you about has been resolved by the NPA. You will be amazed.
That's how easy it was. He said it was easy to resolve it.
Well, it was subsequently resolved after the fact.
Yeah, very easily.
For purposes, I'm reading from paragraph 4. This is it paragraph 4? What is this? It's page 127. Page 127. You don't have it.
Sorry, we don't have the document.
Okay.
It's maybe our oversight. We did ask you for the document, and then you said it was on your client's laptop, and we never got back to you to take it off the laptop. And so we'd completely forgotten to do that.
Yeah.
But it's not on the internet, and we weren't able to get hold of it anywhere else. Knowing that you had it, we didn't look. We just slipped our minds to get it.
One.
There is a later one, but the one Advocate Ramaweli is referring to, we don't have.
First June 2015, you said, ne?
Yeah, 1st June 2015, yes.
Thank you.
Except that there's a later one, is it different from that one?
It's a version that resolves the difficulty that Advocate Mrwebi had in 2011.
Can I find out, because I keep looking at time, if there is that resolution?
No, I just want to read the paragraph and then I'm done. And then maybe we
Then we can take notice of it, and then
Yes,
we can get
yes,
the
yes.
document later. Thank you.
For purposes of, and I'm reading on page 127, paragraph 4, the title of the document is Prosecution Policy Directives, version date 1 June 2015. Paragraph 4, for the purposes of ensuring such consultation, the special director or regional head delegated by the special director or relevant DPP shall determine and agree on all such matters where consultation will be required, as well as the nature and form which such consultation shall take. The agreement may be amended from time to time as the need arises. Then paragraph 5 says, this is the paragraph that I just wanted to read. And any comment?
I mean, so far not. If they have to resolve it by agreement, they have to resolve it. That doesn't change the need for there to be agreement.
I'm done. I only have the document that we initially wanted to produce.
The spreadsheet.
The spreadsheet, yeah.
You just want to submit it, isn't it?
Yes.
Yeah. It is on record that you have submitted it. It can be used as part of the evidence.
Otherwise, I know Advocate Moroga. I'm done. Yeah.
With your,
To our agreement.
with your leave, Chair, can I
Today's parcel.
housekeeping before we even start, Mrs. Bauer? Do you think you should do this today and then postpone it because you've indicated that you will not finish? Or do you want to find another day or go on today until we get to?
We're getting pretty close, and you need to leave at 12, and we're there. The only other time slots that we could possibly fit this in is if our witness on Friday doesn't come, because we're only getting confirmation of that on Wednesday. Alternatively, the 18th, and the only person who wasn't available on the 18th was Advocate Rip, who's in the SCA, but he's not involved in this. I don't know what Mr. Masuka's position is on the 18th. At the time we did the schedule, you were okay, but I don't know if that's changed.
Ma'am,
Rip,
Advocate Dramaweli did do the cross-examination, so he's up to speed on that. So if anything should come from re-examination or questions from the panel,
he will be here.
he would be the man who in any case would be capable to deal it. So I don't think we should delay Ms. Bauer's birthday celebrations any longer.
You are such a party pooper. We were going to surprise her.
I'm sorry, ma'am.
Why do you mention it?
Obviously, I'm pro non-scripter, ma'am. But so I think it would make any difference if I'm not here on the Monday.
It's very
Thank you,
kind of you. Thank you so much.
I've become available on the 18th, so the 18th will be okay.
So
That
can we
Thank
do
you.
it first?
And the 18th is actually my official birthday, so I would like that known as well.
One, is there such a thing? We'll deal with it later, not now.
It does seem that first prize would be if our witness, well, Mr. Hofmeyer, our first prize would be the 15th, which is on Friday, and our second prize would be Monday, the 18th. Friday being subject to whether Mr. Greasy who is indicated to us that he will advise us before the close of business on Wednesday as to whether he's going to testify on Friday or not. So those were our two potential gaps.
Chair, I'm available on Friday, but my learned friend, unfortunately, cannot get out of her commitments. So if she can try, and maybe
It's a re-examination. Although some questions, hopefully Ms. Bauer will not introduce new issues, because we have undertaken to give Council an opportunity to address any new issue which might arise during re-examination.
Madam Chair, I would prefer to be with Mr. Hofmeyer. I just have somebody driving in from Middelburg for a consultation, so I will prevail on them. It's 8 o'clock in the morning. So
until what time?
I have no idea. I don't know what. It's an attorney, so I have regular contact with him, but I'm not quite sure which matter he's going to speak to me about. I think at this point in time it's a part of the trial that he wants me to take over, but I don't have a lot of detail yet.
We have a whole day. We might set aside a particular time on that day.
I would imagine that we should be finished by 10 o'clock. I cannot see that it should last longer than that.
To have the consultation start at what time?
8 o'clock.
8 o'clock. Could start at 6 o'clock.
If the attorney is willing.
I'm just kidding. Yes, I think we can set aside a time. You can just consult with Ms. Bauer and see if we can arrange a later time for the re-examination.
Thank you.
A later than usual time for the re-examination. But
Thank you
on
very
that
much.
day, because it seems like we are all available on that day. It was just that time that you can't do it.
Thank you.
Communicate with Ms. Bauer. Ms. Bauer?
We leave it as first prize Friday, second prize Monday, subject to what we get told by the end of tomorrow, and then I will send out an email or tell you all on Thursday what it would be. Could that work?
Mr. Hofmeyer, you comfortable with that? I think
I
yes.
am, thank you.
Thank you.
Thank you, Chair. Thank you.
Mr. Ramawel, thank you very much. Ne? Yeah, thank you. And thank you, Mr. Hofmeyer. See you on Friday.
We have a witness on Thursday.
Oh, Thursday. Okay.
No, we're having Advocate Mokgoro is giving evidence on
Oh, no, I was saying
Thursday.
we see you on Thursday, but you on Friday. Yes. Okay, thank you so much, everybody. Yeah. We adjourn until Thursday, 10 o'clock.